Asianix lodges its challenge to ElectroAce's nominated arbitrator, and within a week, the SIAC Court of Arbitration convenes a committee to consider this. Though it is not normally the practice, the President of the Court of Arbitration has appointed himself to the committee in recognition of the scale and complexity of the case and the challenge.
Hello guys, thanks for coming. Thanks for taking this 12th shot. But now let's get ready for our job this afternoon. John and Gary, thanks very much for coming this afternoon. It's good that we can meet in person because we're all in Singapore instead of doing it by email. Now I hope you don't mind, but I've asked Alex to join us. Alex, thanks very much for coming today. What I'd like you to do is take notes of our discussions. Afterwards, we'll probably ask you to draft an opinion of the committee for us to have a look at, and that'll eventually be sent to the parties. It may be that we'll want some other things too, so we'll let you know as we get on.
Of course.
Well, getting on to our business for today, we have a challenge to the respondent's arbitrator. The challenge is founded on two bases. The first is that the arbitrator was counsel for one of the parties 15 years ago.
How many years was that?
15.
Okay.
There's also an ancillary point that the arbitrator, when he was counsel, was paid a large bonus. So it's the first ground for challenge.
Just one occasion, one appearance as counsel.
That's all we have on the record.
Do we know what the bonus was?
No, I don't know.
Okay.
Do we know, Alex, what the bonus was?
No.
Okay. So we'll assume it was a reasonable bonus, if not substantial. The second ground for objection is that the arbitrator's son-in-law is married to the respondent's counsel's daughter. Sounds a bit complicated.
So how does that work? The arbitrator has a son who's married to the daughter of the respondent's counsel, or the other way around?
No, I think it would be the arbitrator's daughter is married to the son of the respondent's counsel.
And the respondent's counsel appointed that arbitrator?
Yes, presumably was involved in the appointment. Nominally, it would be the party, of course, but presumably counsel recommended the arbitrator.
Right, and presumably reached out to him and
exactly
did the interview and what have you.
So let's start by going back to basics, and the basics are our rules. And if we have a look at Rule 11.1, it says that an arbitrator may be challenged if circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. So impartiality, as we know, suggests that the arbitrator has said or done something which indicates that the arbitrator is not entirely impartial but really has a bias.
A subjective bias.
Yes, although some of the books say it has to be determined objectively, but it does relate to the arbitrator's state of mind in a sense.
Right.
I don't think we're faced with that here. What we're faced with is a relationship. And so I think this raises the question of independence.
In both cases?
In both cases. Is the arbitrator independent? Now, let's consider these grounds for challenge one by one. So the first ground for challenge is previous act in being counsel by the arbitrator for one of the respondents 15 years ago, and getting the bonus as well. Now, John, let me turn to you first. What's your view?
I think my initial view on this would be that the events are just so far in the past, 15 years ago, that they really shouldn't be relevant. They should have no bearing, particularly as there has not been any sort of ongoing relationship. It's a one-off event. That would be certainly my initial take on things. But what I would usually do in this sort of situation would be look for some comfort in the IBA guidelines. Say what you like about the IBA guidelines, but they're the sort of, I'd say, the international consensus, if not the international best practices, and I think we should take a look at those. If that guides you.
I'm not so sure about that. I've always had some skepticism, as you know, about the guidelines. They're not a statute. They're not binding on us in any way, and I'm not at all sure that they're international consensus. You certainly encounter lots of folks who have considerable doubts about many of the provisions, and I, for one at least, don't understand how the Orange List purports to function.
Maybe we could look at the specific situation we have here in the light of the guidelines, because they do, I think, address more or less head-on the facts we're talking about.
I think the guidelines are a love-hate sort of system. Some people think that they're very useful, others have questions about them, but it's probably the only thing we have which objectively enables us to test from at least one perspective whether or not this relationship is seen as unduly infringing the arbitrator's independence. So let's have a look anyway and see what they say.
The guidelines are not rules, so we don't have to follow them, but it might be instructive to take a look.
What helps us there?
Well, if you look at the Orange List, and that's actually the first item on the Orange List, which is, as I say, pretty much on all fours with our situation. So Article 3.1 is previous services for one of the parties or other involvement in the case, and there's gets then more specific in 3.1.1 about what sort of facts qualify for inclusion on the list.
Yes.
And so you have 3.1.1, the arbitrator has within the past 3 years served as counsel for one of the parties, but the arbitrator and the party have no ongoing relationship.
So do we reason from that if the service was more than 3 years ago, it's not relevant?
I think we do reason from that, or at least that's what we're being guided towards by the guidelines. And we're not talking about 4 years or 5 years. We're talking about 15 years, and with no ongoing relationship after that. So I think I would follow the guidelines and come to the conclusion that really it wouldn't be on the Orange List. That means that there's, at least in the views of the authors of the rules, there's no justifiable doubts as to independence, and therefore no reason to disclose, and I think that would lead to dismissal, and that sort of comforts my initial view as well.
Gary, what's your view?
I think I come to the same conclusion, although perhaps for slightly different reasons. Again, I have great hesitation using the guidelines in this case. The 3-year rule addresses whether something should be disclosed, not whether it's grounds for removal. I think we can conclude if you don't have to disclose something, then it, by definition, can't be grounds for removal or disqualification. Unfortunately, the guidelines don't tell us anything about the size of the case or whether this particular client had other cases in the intervening 15 years.
There is an allegation that the then counsel received a substantial bonus. Is that relevant?
I do think it could be relevant, and I think what we need to do is focus on the specific facts and circumstances of this individual case. So far as we can tell from the materials we received in the challenge, and it is a rather skeletal challenge, I have to say, there's no indication of any other repeat business, if you will, repeat appointments or anything of the sort between the respondent and the arbitrator. And in those circumstances, and not knowing the size of the bonus, I think we can fairly conclude that there's not a sufficient basis for challenging the arbitrator's independence.
Yeah, I would say that I don't think a bonus is an atypical manner of remunerating the services that were provided, so I would agree with that.
Yes, I agree with you. I don't think getting into the basis of remuneration is relevant unless there's something really extraordinary about it. So I think we can probably lay the first ground for challenge to rest. It's not a strong ground, and I think we all readily agree that it's not a basis for removing the arbitrator. Now, the second ground is perhaps a little more tricky. The second ground relates to a familial relationship between the daughter is married to respondent's counsel's son. And that's the relationship as I understand it. I hope I haven't got it around the wrong way. I don't think so, though. So here we have a family relationship, not with the party to the arbitration. So there's no assertion that the arbitrator is related to a party, but to counsel. And how do we approach this one? Do we look at the IBA rules? Do they help us on this? John, Gary, what's your view?
Notwithstanding my hesitation about the IBA guidelines, I have taken a look at them in this case. And on the waivable red list, which requires a party's specific consent, if I understand it, to the arbitrator having one of the listed conflicts, there is in section 2.3.8 a provision that comes fairly close to these facts. Let me read it out and then we can discuss it. The arbitrator has a close family relationship with one of the parties or with a counsel representing a party. And so the question here would be, does the arbitrator have a close family relationship with respondent's counsel by virtue of his daughter being married to respondent counsel's son?
So there is a relationship.
There's clearly I believe there's clearly a family relationship in the sense of the respondent's counsel's son is the son-in-law of the arbitrator, and so there's a family relationship, at least by marriage. Now, there's a footnote in the IBA guidelines that says, throughout the application lists, the red, orange, and green guidelines, the term close family member refers to a spouse, sibling, child, parent, or life partner. And if we were to parse that precisely, the reference to child would appear to be a reference to a natural child, not, if you will, a daughter or a son-in-law. And by that interpretation, I think one would fall outside, at least technically outside, the scope of Article 2.3.8. It would be a family relationship, but not a close family relationship.
But as you said, the IBA guidelines are not binding, they're not law, they haven't been adopted by the parties.
And they can't cover all the eventualities.
No.
This is quite
They're just examples, aren't they?
The footnote does purport to define close family relationship. I guess for my part, I'd rather try and look specifically at the facts and circumstances here. Relevant to me would be what are the character of the two families? What's the relationship between the son and the daughter? Do we in fact know whether they're still in a happy marriage or marriage at all?
Is it a close family?
Exactly.
Yeah.
And really, the relationship between the arbitrator and the counsel, I think. I mean, how close is that as well?
Presumably, they're related through their children in a sense. Presumably, they see each other from time to time, have dinner. I mean, we don't have evidence as to how often they meet.
Perhaps we can ask the counsel as to what is in the application. Is there further information about the nature of this family relationship?
Alex, what do we have on file about this? Do we know what the relationship is between the arbitrator and respondent's counsel? The personal relationship, do they meet a lot? Are they close? What do we know about it?
All we know right now is that the children are still married, but beyond that, the claimant has not indicated any particulars.
Okay, thank you. Well, I guess we can try and get further information if we think it's relevant, or do we think that the relationship is not close enough to justify asking the arbitrator to step down?
I've forgotten what the file says about the arbitrator's comments in response to the challenge.
Yeah. We don't have them before us, unfortunately.
He might have, or might be asked to comment on that, because his view about the closeness of the relationship, I guess, would figure, at least in part, in my thinking.
Yes, I mean, it's our usual practice to do so. We don't appear to have done so on this occasion.
But to answer your question, Michael, I think that we can't say the relationship is so tenuous that we should dismiss the challenge. I do think it requires further look into the facts and further consideration.
Yes.
I agree with that.
So let's look at it from the claimant's perspective. Does the claimant have a real fear that there's an appearance of unfairness because of this relationship. If you were a claimant, would you feel uncomfortable proceeding in an arbitration where the other side's arbitrator had this relationship with counsel through their children?
Absolutely.
You would feel uncomfortable.
I think one has to look at it in the context of each party's right, freedom to nominate an arbitrator of their own choice and the process that leads up to that nomination. And as we all know, both parties, through their counsel, will have interviewed the co-arbitrators.
Yes.
And will have chosen people in whom they have confidence. And I think one has to assess this family relationship against that baseline, and it's much less clear to me that this is something that a claimant legitimately can be concerned about. And again, I would be potentially moved by what the co-arbitrator had to say about the relationship.
So we could go back and see if we can get further information. But so do we at this stage, do we have a firm view one way or the other as to whether this is likely to furnish a basis for asking the arbitrator to step down?
I think it's very close.
I think it's a hard case, and I would like to go back and get further information if we can.
Well, of course, it's a grave responsibility we have here, because a party has a right under our rules to nominate an arbitrator, and that's a very important aspect of international arbitration. That gives international arbitration, to some extent, universal appeal. But on the other hand, the other side has a right to have an impartial and independent tribunal. So there are two issues here which bear on this question. Rather than force the issue on such a delicate question, my suggestion is that we ask Alex to contact the parties to see if we can get further information. And then I think this matter really ought to be referred to the full court of arbitration, because it is a borderline case, and I'd like to hear the views of the whole court.
I think that's exactly right.
Yeah.
John, you agreeable to that?
I agree.
Alex, we've concluded our deliberations now, so would you be good enough to write notes of what we've been speaking about? Would you also please contact the arbitrator and respondents' counsel and get further information about their relationship, how often they meet, and anything else they can provide us with in relation to that. When you've got their responses and you have your full notes of this session of the committee, please pass it on to the full court and then ask the full court for its decision on the second ground for challenge. Once you've got their decision, then write up their reasons for decision, and those reasons, together with the reasons for the rejecting the first ground for removal of the arbitrator, will form the basis of the reasons for the court's determination of the application.
Yes, sir.
Thank you very much. Thank you very much for coming.
Thank you, Michael.
So it seems the Court of Arbitration has decided to reject the claimant's challenge, and the respondent's nominee will continue on the tribunal. The court has also made a decision on the costs of this challenge, in this case, deciding that the claimant should bear the costs. The court's decision is final and not subject to appeal, although the claimant can approach the Singapore High Court to ask for a review of the decision, if it chooses to. For now, the arbitration can proceed to the next stage,